who or those who wish to make a claim. In terms of S to 10, this is false. Honourable Minister, you are conducting a monologue. I asked a simple question. Yes or no, are you for or against the bilingualism for the judges in the Miscarriage of Justice Commission? I appreciate your work. You're an honest man, a serious man. I don't understand why you're just avoiding my question. Just say it simply, and then I'll move on to the next one. You've tried to address several different files. No, I said I would have liked to, but I didn't. With S210, what I'd like to point out is that age-appropriate design features is in Bill C-63, and we always must safeguard privacy rights of Canadians. We only have a little bit of time left. Are you going to continue with this dialogue, Mr. Minister? We have age verification. Well, I have to give up on my turn because I understand that the minister does not want to answer my question. I'm giving the 30 seconds to one of my colleagues. Perhaps they can get him to talk about a topic that he wishes to talk about this morning. Thank you, Mr. Minister. May I continue, Madam Chair? You can't continue.
Madame la Présidente.
Madam Chair, may I continue for 20 seconds? I should be able to be the one in charge of my turn. It's a monologue, which is of no interest to me, with all due respect.
Sure, we'll let the minister continue. Mr. Garrison.
No, I won't. So I want to thank the minister for his very clear presentation on C-63. And just I want to add two things to this discussion. One is that the loudest voices about this bill are often do not include those who are most likely to be subject to hate crime campaigns. So when it comes before this committee, I'm looking forward to a diversity of witnesses who can talk about the real world impacts that online hate has. And we've seen it again and again. And it's often well organized. I stood outside the House of Commons and defended the rights of trans kids. Within one day, I had 700 emails with the same two-word defamatory and hateful phrase used to describe me. And now, I'm a privileged person. I have a staff. I have all the resources and supports I need. But when you think about what happens to trans kids and their families when they're subjected to these online hate crimes, it has very real consequences. So I'm looking forward to us being able to hear from diverse voices, and in particular those who are most impacted. And I know this is not really a question to you at this point. But we have other important work we've been doing in this committee. And so I want to turn to C-332, which just passed this committee, was sent back to the House. And this is the bill on coercive and controlling behavior. And this committee has been dealing with this topic for more than 3 years. And one of the things that we quite clearly said, that passage of this bill is a tool for dealing with the epidemic of intimate partner violence, but it's not the only tool. And so I'm asking, I guess, two things here. What other plans does the Department of Justice have to provide the necessary and associated supports for survivors of intimate partner violence? And what plans are there to do the educational work that will be necessary? Because the bill says it will be proclaimed at a time chosen by Cabinet. So I'm assuming there will be a plan to get ready for this. And I'm interested in what's going to happen with that plan. Because it has unanimous support, I don't think it's premature to be asking about this at this point.
So thank you, Mr. Garrison, for your leadership on the first part of what you talked about and the courage you continue to show as a parliamentarian, and secondly, for your leadership in that of Laurel Collins on coercive control. What I'd say to you is that in terms of sort of supporting victims, we are constantly and actively thinking about how to better support victims, including victims of intimate partner violence. What I'd say to you is that please also take a cue from what we did in Bill C-75 and in Bill C-48 with respect to the reverse onus on bail for survivors of intimate partner violence. Issues about sort of support and funding are always on the table. What I would also say to you is that don't hesitate to also understand that when you talk about 24-hour takedown of things like revenge porn, you're dealing with an aspect of coercive control that exists right now. So that's in Bill C-63. And what I would say to you also is that you mentioned sort of in your opening about hearing from voices. I think two of the most salient voices that I heard from were the two that were there at the press conference with me. Jane, the mother of a child who has been sexually abused and exploited online repeatedly, and also Carla Beauvais, a woman who has been intimidated and cowered from participating in the public space. I'd also say take your cues from the groups that were there also beside me. The National Council of Canadian Muslims and the Centre for Jewish and Israeli Affairs have in the last 6 months not seen eye to eye on a lot of issues. On this bill, they do see eye to eye. They both support this, as do the special envoys on anti-Semitism and Islamophobia. Those are important voices to be hearing from, and that's what I will continue to do.
I just want to continue a little bit on the question of legal aid when it comes to intimate partner violence. And I know that quite often the answer is that, well, that's really responsibility of the provinces. But I guess what I'm looking for here is some commitment to the federal government, perhaps with new pilot programs or new funding to encourage new programs in areas of intimate partner violence and support. Because the change in the law will mean that intimate partners will be involved in a process, a criminal process, but they will not be the defendant. And so quite often there isn't legal assistance available for people who may face a period in court in very difficult circumstances. So I'm looking for some leadership from the federal government in this, even though I recognize it's primarily a provincial responsibility.
Well, I think we both have a role to play, in fairness, Mr. Garrison. So I would say that we have a role to play in providing dollars. The on-the-ground delivery is often sort of administered by provinces. We've been quite strong in terms of our support for both immigration and refugee legal aid and criminal legal aid. But I would reflect back on what the chair mentioned about targeted supports in Nova Scotia for racialized communities. I believe strongly in supporting vulnerable people who are in need of legal aid assistance. So if there are proposals that are put before me about how we can address legal aid in an acute manner that helps women in the main who are dealing with intimate partner violence, I am all ears for that kind of discussion, because I think those kinds of targeted supports are necessary to really fulfill the promise of ensuring that people's rights are vindicated.
Thank you, and we will follow up with you on that. Mr. Van Popta opened with a question about confidence in the justice system and the appointment of judges, and I think we all acknowledge that this whole system has to do better in terms of filling judicial vacancies, and I do acknowledge your personal efforts to do that. But there's a second part to confidence in the justice system, and that is people have confidence in the system when they see themselves represented in the system rather than just subjected to it. And so I wonder if you could comment on the nature of the judicial appointments and how progress is being made, if it's being made, to make the judiciary reflect the face of Canada.
I'd very happy to address this. When we took office, about 30% of the Conservative government's appointments had been women. 53% of our appointments are women. When I came into office, the record of our government is about 11% racialized candidates being appointed. I've appointed 20% racialized candidates. I believe strongly in a strong, highly intellectually competent bench, but also a bench that reflects the diversity of our country, because I believe that that helps ensure confidence in the administration of justice.
Thank you very much, Minister, and thank you, Mr. Garrison. We will now commence with our second round, and we'll go to Mr. Moore for 5 minutes.
Thank you, Madam Chair. Minister, we're here on the estimates today. You spent your entire speech, opening remarks, on a defense of Bill C-63. And I recall your predecessor, Minister Lametti, when he was here. And I asked him a question. It was on the issue of MAID, when I think 25 constitutional experts said the minister's opinion on the matter was wrong. So I asked the minister, who's right, you or these 25 constitutional experts? And he said, I am. And that kind of hubris is probably a good reason why he's no longer here, and now you are. But we're starting to see that same thing on C-63 with yourself, when virtually everyone has come out and said that this is an effort to tramp down on freedom of speech. Even Margaret Atwood described Bill C-63 as Orwellian. David Thomas, who was chairperson of the Canadian Human Rights Tribunal, he said, and I'm quoting him, "The Liberal government's proposed Bill C-63, the Online Harms Act, is terrible law that will unduly impose restrictions on Canadians' sacred charter right to freedom of expression. That is what the Liberals intend. By drafting a vague law, creating a draconian regime to address online harms, they will win their wars without firing a bullet. So there's a diverse group of people that feel that Bill C-63 is an outrageous infringement on Canadians' rights. And we also see a government that will not stand up for the most vulnerable. Instead of a bill, you had the opportunity, Minister, to introduce a bill that would have protected children. But your government, true to form, could not resist taking aims at their political opponents. This is not about hate speech. It's about speech that liberals hate and shutting that down. And now Bill C-63, if it ever unfortunately were to pass, it too will be struck down by the courts. And if you were in a position to appeal it, I have no doubt you would. And that brings me to my question on your government's radical agenda. You've decided to file a number of appeals in recent court rulings. You've appealed a ruling that found the invocation of the Emergencies Act was unconstitutional. You appealed a ruling that found that the plastic bag ban and the plastic straw ban that Canadians hate so much was unconstitutional. You were quick to appeal those. But when the Supreme Court ruled that the 6-month minimum sentence for the crime of child luring was unconstitutional, you chose not to file an appeal. So, Minister, why is it when your government's radical agenda is challenged in the courts, you're quick to appeal, but when vulnerable Canadians' lives are at stake, you choose not to appeal?
Mr. Moore, I'll say to you that I disagree with pretty much everything you just said in terms of how you've characterized things. And what I'd say to you is that look at actually the constitutional record internationally. We looked at France, Australia, Germany, England. In France, a takedown provision across all sets of content, including hatred content, was struck down as unconstitutional. That's specifically why we are not pursuing that. We have a takedown provision within 24 hours of child pornography and revenge porn. I'm sure and I hope we can agree on that, Liberals and Conservatives. We do not have an immediate takedown provision over other materials. That's the first point. The second point is that you talked about the author Margaret Atwood. I have tremendous respect for Margaret Atwood. I've invited her into a conversation about the nuances of this bill. She has a concern about freedom of expression. I share that concern. I'm duty-bound to uphold freedom of expression. I swore an oath to the Constitution. I'm the only cabinet minister that does. What we've done through a careful approach is look at how we can calibrate the important need to keep Canadians safe and to protect liberty of expression. If you listened to Carla Beauvais at the press conference, Mr. Moore, you would have heard her talk about the fact that her own speech is being curtailed because she is so intimidated from participating in public discourse. We're trying to empower that public discourse. There are safeguards in the bill, Mr. Moore, that I would urge you to look at about how Facebook makes its determinations in terms of ensuring that they respect freedom of speech, how the Digital Safety Commissioner must ensure that non-discrimination occurs, and how courts would review these processes to ensure that liberty of expression is always maintained.
Madam Chair, we're going to have lots of time to debate Bill C-63 in the future. I think the verdict is coming out very quickly on that. I do want to use what's left of my time to move now my motion regarding former Minister David Lametti on the issue of ex-Judge Delille, where the minister ordered a new trial. So I'm moving that motion now, Madam Speaker.
Thank you. I recognize Mr. Maloney.
Are you proposing to debate the motion now, Mr. Moore?
Well, I'm assuming there would be near unanimous support for it in light of the stories coming out of Quebec right now about Minister Lametti ordering a new trial in the case of this judge that was found guilty of murder. So if we can have, if it can pass by unanimous consent or have a vote on it now,
Madam Chair, then, given that we're here.
Hold on. Yes. Mr. Maloney, you have the floor.
Thank you, Madam Chair. I was going to say, given that the minister is here at the request of all parties and with enthusiastic support from the opposition, I would move that we adjourn debate on this motion, get back to the issues at hand, because not only do we have the minister here, we have the officials here. I think we should use the time we have to discuss the issues we're here to discuss.
Okay, we need to take a vote on this.
Madame la Présidente,
Oui?
sur la motion pour ajourner de M. Maloney, j'aimerais intervenir.
On the motion to adjourn, I'd like to intervene. May I?
Okay.
No.
Maintenant.
On vote.
So we vote to know whether we adjourn the motion. May the minister be allowed to answer the questions we have on the budget? And if the minister refuses to answer, then do we move on to Mr. Murr? No, no. We have not finished the first hour. Clerk, could you take the vote?
Vote? Yes, okay.
Okay. So on the motion to adjourn the debate,